regional expertise and experience and wisdom on the issue of torture and the remedies and reparations that are owed to victims of torture. It's particularly meaningful to have this kind of regional expertise and perspective right now when the U.S. is facing a real crisis in terms of how do we move forward? How do we handle, remedy, face the truth, and deal with what our own government has done? So I'm really pleased to have you all here. I'd like to explicitly thank all of our co-sponsors, Sahil, Connect Us, CELS, WOLA, the ACLU, and NYU DC. We're extremely grateful to have you all here and very honored by your presence. Thank you.
Thank you. Thank you all for being here. I'm Jo Marie Bird. I'm a senior fellow at the Washington Office on Latin America. And this event today arose as a result of a collaboration between all the organizations that were just mentioned who are participating in a hearing tomorrow at 9 a.m. before the Inter-American Commission on Human Rights about the CIA torture policy. So that is open to the public, so I encourage any of you who are interested to please attend. The dynamic for this afternoon's event will be each of our 4 presenters will have 10 to 12 minutes to just give a brief discussion about their experience. We're very interested in hearing the experience of people who've worked in Latin America on the torture issue and ongoing efforts in Latin America to achieve accountability as well as reparations for victims of torture and other grave human rights abuses. So we'll have these brief presentations and then we'll open it up for a Q&A conversation with those of you in the audience. So I'm going to introduce each of our speakers by turn. So we're going to start with the Reverend Fred B. Morris. Reverend Morris is a Methodist pastor and a torture survivor, and he's going to speak to us first.
Thank you. I'm going to read my statement because you have threatened me with dire consequences if I go over my 12 minutes.
Correct.
And I've timed myself, and I think I can do this in 12 minutes. I want to offer my most profound thanks to the panel sponsors for the invitation to be here today, participate in these proceedings. I also want to praise them for their efforts to bring a modicum of justice for all those who were victims of the military regime that dominated Brazil from 1964 to 1985, as well as for the untold hundreds who were victims of the CIA renditions and tortures following the tragic events known popularly as 9/11. At the beginning of 1964, I was sent to Brazil as a missionary of the United Methodist Church. When the military overthrow of the elected government took place on April 1st, 1964, I could not yet read Portuguese and not understand it, and I had very little comprehension of what was taking place at that time. For the next 11 years, I would serve the Brazilian Methodist Church as a pastor in various places, starting in Teresópolis, Rio de Janeiro, Rio itself, and then in Recife, Olinda in the Brazilian Northeast. In 1970, I was assigned to serve in Recife, Olinda, where, among other things, I was to develop working relations with Archbishop Noel Câmara, a leading Catholic prelate, an outspoken opponent of the military regime that had been in power since the CIA had orchestrated the overthrow of the elected government in 1964. Beginning in the fall of 1969, the Brazilian military began to show its displeasure with Dom Helder by kidnapping and murdering a young priest in Recife. Each year after that, between 3 and 8 persons associated with the Archbishop were kidnapped and tortured by the military in an effort to intimidate the Archbishop into silence. On September 30, 1974, because of my close relationship with Dom Helder, I was kidnapped by the security forces of the Brazilian military and spent the next 17 days in their torture chambers. Yes, I was tortured with beatings, electric shock, sleep deprivation, solitary confinement, and a staged execution. Because of the active intervention of the U.S. Consul in Recife, Mr. Richard Brown, and the U.S. Ambassador in Brasilia, Mr. John Crimmins, I was eventually released and deported from Brazil as a person prejudicial to national interests, which in those days was a compliment. I will not go into more details of my torture, as many Brazilians were tortured much more than I was, but I will just point out 2 important details. First of all, Major Maya, the head of the torture section where I was held, bragged to me about being a graduate of the School of the Americas, then in Panama. He said he was a Christian, fighting with the U.S. against godless communism. At one point, he made very clear his close association with the CIA in Recife when he offered me my rehabilitation if I would confess to being a CIA agent infiltrating Doelder's activities. Second point is that the torture methods used on me were identical to what we all saw in 2003, 2004 at Abu Ghraib in Iraq, proving again the close association between the Brazilian military and the U.S. Army/CIA. After my expulsion, Time magazine, for whom I had been a stringer in Recife, published a 2-page first-person account that I wrote on torture Brazilian style in the November 18, 1974 issue of that magazine. Then Time got me on the Today Show for a 10-minute interview, and then 26 other talk shows around the United States and Canada. And WOLA arranged for my appearance before a congressional committee on December 11, 1974, where I told about what had happened to me in Brazil. I also published a larger account of my torture in Harper's October 1975. I spoke at more than 150 universities and churches, all the way from Yale and Harvard to UCLA and in between during that period of time. The result of all this activity, along with the efforts of WOLA and other concerned groups, together with letter-writing campaigns by thousands of United Methodists across the United States, in June of 1976, the U.S. Congress cut off all military assistance to Brazil, and that aid has never been renewed. However, I paid a price for all this activity. All opportunities for employment were closed off to me. I looked for work for 21 months here in Washington, D.C. without getting as far as an interview. I had been blacklisted by the CIA. In November of 1974, Senator George McGovern, in an effort to assist me in finding employment, actually inquired at government agencies about the possibility of my being hired by one of them. As someone who was fluent in Portuguese, had spent time in Latin America, he was told clearly that I was not employable. For more than 30 years, I experienced various kinds of persecution. As the blocked opportunities for employment put my family at risk of hunger, in June 1976, I went to Costa Rica to establish my own construction company. On arrival in Costa Rica, I discovered that I was being watched by the security forces of that country and by the CIA. My telephones were tapped. My offices had their doors forced on more than one occasion. I was detained at the airport in San Jose by Costa Rican security forces on return trips from Nicaragua many times. My wife also was harassed by security agents until they discovered, much to their chagrin, that she was the private secretary to the president of Costa Rica, Don Rodrigo Carazo. After 12 years in Costa Rica, we returned to the United States, where I resumed pastoral ministry with the United Methodist Church in the Chicago area. In 1988, as a result of heroic efforts by my spiritual brother and dearest friend, Father Marcelo Barros, a Benedictine priest and noted Brazilian theologian, the expulsion decree signed by General Ernesto Geisel in 1974 was revoked by interim President Ulysses Guimarães, and I could return to Brazil. It is difficult to calculate the material damages that I experienced. At the moment of my kidnapping by the Brazilian security forces, I was earning a salary of $1,600 a month in Recife, which in 1974 was a very good salary. I was general manager of a concrete block manufacturing company. What did I lose in salaries? If I had continued to work in that company without any increase in wages until the age of 65, I would have earned $520,000 in salaries. I also paid into the Brazilian Social Security system for 13 years that I worked in Brazil, but I cannot receive any pension because I did not have enough years paid into the system due to my expulsion. As to moral losses, my reputation was destroyed by the unfounded accusations of the Brazilian army that on the one hand I was a communist and on the other that I was a CIA agent. Very interesting combination. My own church rejected me because of those accusations, which caused me more pain than the actual tortures at the hands of the agents of the Brazilian government, as I had never anticipated such a rejection. It was like being rejected by my own family. In the 1970s in the United States, to be accused of being a communist or a CIA agent was the kiss of death. Spiritual damages. Before 1974, I had made a commitment to spend the rest of my life in Brazil, seeking to serve the Brazilian people. I was exiled for 14 years, and after that, I did not have the financial resources to be able to return permanently. My two Brazilian children and my second marriage, Jessica Raquel Carvalho Moras, who is present here today, and her brother, Eric José Carvalho Moras, were denied regular contact with their father for many years. Because after my divorce from their mother and their subsequent return to Brazil, I could not even visit them. There is no way to calculate the spiritual costs. The Brazilian army made a huge mistake in kidnapping and torturing a Methodist missionary. In 1974, the Methodist Church in Brazil was relatively insignificant, with 30 to 40,000 members in the entire country. But the United Methodist Church in the United States was the second largest Protestant church in the country, with nearly 10 million members. And at the moment of my abduction and torture, of the 535 members of the U.S. Congress, 100 of them professed membership in the United Methodist Church. So when word got out that a United Methodist missionary had been kidnapped and was being tortured in Brazil, it created an enormous reaction in the whole country. Certainly it was this that saved my life and the life of my friend Alanir Cardozo, who was kidnapped and tortured with me. Because after all the uproar in the Congress of the U.S. and in the international press, it was better for the Brazilian military to let me go and expel me than to keep me in prison. And in the story and time and the many television interviews, I made a point to name Alanir and hold the Brazilian army responsible for his life. Now I need to make some observations. Point one, there can be no doubt that the U.S. Army and CIA were directly involved in the events that led to my kidnapping and torture. As I said earlier, Major Amaya bragged about being a graduate of the School of the Americas, where he, along with thousands of other Latin American military, learned the ideology that led to the torture, murder, and disappearances of thousands of persons. In the 1990s, manuals on methods of torture identical to what I experienced were discovered at the School of the Americas by congressional staff. Second thing I want to say is that on December 11, 1974, as WOLA's first client, I was invited to testify before a congressional committee. At the conclusion of that testimony, I said the following: torture brutalizes and dehumanizes not only those who are tortured, but those who torture, those who are intimidated by the torture of others, and those who try to ignore the fact that torture exists. It dehumanizes those who are tortured by treating them as less than human, and in many cases by forcing them into less than human feelings and often into less than human acts. If one is forced to betray friends, companions, and family through torture, as many are, the psychological and spiritual damage may be irreparable, quite apart from the permanent physical damage that often results. It dehumanizes those who torture in addition to the psychopathology induced and encouraged in those who practice torture. Persons and governments who resort to torture for whatever motives betray their social contract with their fellow humans and effectively secede from the human community. Torture dehumanizes those who are intimidated, churchmen who cease to proclaim the gospel in its fullness out of fear, students who cease to make the search for truth their vocation out of fear, journalists who give the public less than the truth for fear of reprisal, workers who through fear of repression are not allowed to organize to defend their interests, politicians who can only rubber stamp authoritarian proposals from dictatorial regimes for fear of consequences, and much more, more independent conscious actions. All these, and in fact the whole community of mankind, share in the dehumanization caused by torture. Torture dehumanizes those who try to ignore it, saying it is an internal affair or a passing phase. Such indifference dries up the well springs of human sympathy and compassion and breaks the social contract of the world community to be concerned for the whole family of mankind. Civilization and freedom are not built and cannot be maintained by those who assume the posture of indifference. Reparations. In August of 2008, I was living in Panama, where we had retired 3 years earlier. I received an email from the Ministry of Justice of the government of Brazil inviting me to appear in Brasilia on September 26 before the Amnesty Commission of that government. When I appeared in the Dom Helder Câmara Salon of the National Conference of Catholic Bishops, the president of the Amnesty Commission of the Ministry of Justice, Dr. Paulo Abrão, stood up before an audience of some 200 persons and said to me, "Reverend Morris, on behalf of the government of Brazil, I want to ask your forgiveness for what was done to you by our agents of our government 34 years ago." He didn't say they'd made a mistake for which they were sorry. He asked for forgiveness. And then as a gesture of his government's repentance, I was awarded a cash gift of some $125,000 and a lifetime pension. I cannot express how overwhelming this experience was. Dr. Abrão was 2 years old in 1974, and President Lula was 29 years old, struggling for his own survival as a labor leader. But that government, 34 years later, has asked for my forgiveness. I cannot overstate the importance of that gesture. Part 3, accountability. Some might think that this comment involves my getting involved in the internal affairs of Brazil, but when the government of Brazil, by means of its army and security personnel, kidnapped and tortured me, it made me a Brazilian because I was in the same situation as the majority of Brazilians, without liberty and without hope. Therefore, I believe I have, even today, the right to make this observation. Until Brazil totally faces and openly what happened during the years between the military overthrow of the elected government and the return to semi-democracy in 1985 and decides to punish those guilty of crimes against humanity, such as kidnapping, torture, rape, murder, and disappearances, all of which are common crimes and not political crimes, it will never heal the wound that exists in the soul of Brazil. When the military club can hold a party with the participation of over 400 high-ranking military officials to honor Colonel Ustra, who was one of the most horrible, horrendous war criminals, crimes against humanity in the history of Brazil and maybe in the world. As long as that can happen, and the torturers continue to be held immune to any punishment, the cancer of the wounds of torture on the soul of Brazil will continue. A final comment. My time is up, but I've got to read this last paragraph. It would not be just on my part in this declaration if it did not make public my strongest repudiation of the government of my own country, the United States of America, for its use of torture and rendition as a measure of combating the so-called terrorists of the world. This government continues to commit the same crimes which I am denouncing here and deserves the repudiation of all the peoples of the world. Even as I observe that the government of the United States in a certain way saved my life in 1974 through the courageous actions of Richard Brown and John Crimmins, they were both threatened with being fired from the State Department by Henry Kissinger because they had jeopardized his close relations with the Brazilian military. The School of the Americas has taught people all over Latin America why to torture, and now we know they taught them how to torture. Torture is against both U.S. and international law and is not permitted under any circumstances, not even war nor in response to acts of terrorism. The people of the United States should demand that those in our government who authorized and carried out acts of torture, including the infamous renditions by the CIA, should be held accountable, indicted, tried, and if found guilty, imprisoned. And the victims of those crimes should receive reparations for the harm done to them. Only in this way can we rejoin the community of nations of the world. Thank you.
Thank you so much, Reverend Morris, for your very moving testimony. Our next speaker is Juan Mendez, who really needs no introduction. He is currently the UN Special Rapporteur on Torture.
Thank you very much, Jo Marie. It's a daunting task to come after Fred Morris with his testimony, but I'm here to speak about my role as the UN Special Rapporteur on Torture, and I really appreciate the invitation by NYU and by all the other sponsors, not just for inviting me today, but also for their steadfast support for the rapporteurship and the task that I've been doing now for 5 years. All of these organizations, the ACLU and NYU Bernstein Center, in regards to United States issues, Connect Us, CELS, and several others with regards to other countries. And I want to take advantage of the opportunity to thank all of you. WOLA, of course, for many, many years of support. I think the publication of the Senate Select Committee on Intelligence last December opened up an opportunity for pressing hard for the United States to live up to its obligations under international law. Before that report, and it was very long awaited, as you know, the report had been written at least 5 or 6 years earlier, and it was not declassified until the Senate Select Committee itself declassified at least parts of it. Before that, the impunity for the torture that had gone on in the so-called global war on terror was complete and absolute. Now, at that point, the truth that comes out of that report does indeed open up possibilities. And the possibility that opened up for me as a special rapporteur on torture, and for the United Nations more generally, because the High Commissioner for Human Rights also said the same, was that the truth-telling is an important aspect of the international obligations of a state that commits torture. But it's not the only one obligation, and it's no substitute for all the other obligations that are part of the international law framework regarding torture. And that the report itself should be the occasion for the United States to live up to its obligation to investigate, prosecute, and punish every act of torture, which is the standard that applies to the international framework on torture. The excerpts that have been released of the Senate Select Committee on Intelligence Detention and report on Detention and Interrogation Program established that between 2002 and 2007, the CIA forcibly disappeared, detained, interrogated, and subjected more than 100 persons to torture and other forms of ill treatment as part of the Rendition, Detention, and Interrogation Program in collaboration with a global network of more than 50 other states. The use of overseas detention facilities, sometimes called black sites, in locations around the world, including Afghanistan, Eastern Europe, Thailand, and Guantanamo Bay, is well documented. In addition, the CIA rendered other individuals to third countries for detention and interrogation. Despite the fact that these practices were approved and coordinated by high-level government officials and carried out by state agents, criminal and civil accountability for the abuses is still lacking. The acts of torture and other ill treatment perpetrated as part of the programs were designed to take place extraterritorially and clandestinely, leading directly to lack of accountability and impunity for the violations committed. In this context, the report and its findings have significant potential for compiling evidence that may be used by the state to fulfill its fundamental international legal obligations to investigate, prosecute, and punish those responsible for committing, for ordering, or for tolerating acts of torture and other ill treatment. The so-called enhanced interrogation techniques, such as waterboarding, stress positions, sleep deprivation, forced nudity, insults and violence, and dietary manipulation, among others, that have been documented in the report, amount to torture or cruel, inhuman, and degrading treatment or punishment. If not on their own, then certainly when used in combination, and especially when coupled with arbitrary detention, lack of due process, and incommunicado and secret detention. The release of the report contributes to fulfilling the obligations of the United States with respect to truth. However, it is only a first step in the direction of fulfilling other U.S. obligations under international law. The report unequivocally concludes that U.S. high officials have promoted, encouraged, and allowed the use of torture after September 11, 2001. The serious abuses detailed in the report constitute basic violations of international law. The United States government has a responsibility to let the American people know what happened during the years when extraordinary rendition, secret detention, and so-called enhanced interrogation techniques were practiced, and to ensure accountability and transparency to the fullest extent possible. The government's reluctance to work with international authorities on the issue of accountability for human rights violations has made it easier for other nations to shirk their responsibilities. In my work around the world, I regrettably find that the example set by the United States on the use of torture has been a big drawback in the fight against such practice elsewhere. As a party to the Convention and as a member of the Human Rights Council, the United States has an obligation to thoroughly and promptly investigate credible reports of torture, to cooperate with international investigations, to ensure accountability, and provide adequate remedies to the victims. In my interim report to the General Assembly of August of this year, that I actually presented to the General Assembly 2 days ago, I elaborated on the extraterritorial application of the prohibition of torture and other ill treatment and other attendant obligations under international law. In this report, I reminded states that the jus cogens, or non-derogable prohibition against torture and other ill treatment in international law, which is applicable to all states, cannot be territorially limited, and that any jurisdictional references found in the Convention cannot be read to restrict or limit the state's obligation to respect all individuals' rights to be free from torture and ill treatment anywhere in the world. This prohibition and the attendant obligations, such as the obligation to investigate, prosecute, and punish every act of torture, to exclude evidence obtained by torture from any proceedings, and to refrain from enabling refoulement to torture or other ill treatment, sending people back to a place where they could be tortured, are norms of customary international law that are also codified in legal instruments like the Convention. The legal prohibition against torture would be meaningless if states are in practice able to mistreat victims outside their borders with the complicity of other states. This is particularly relevant to the cases of extraordinary rendition, secret detention, and torture conducted by or with the involvement of the CIA in the aftermath of September 11, 2001. Whenever states bring a person within their jurisdiction by exercising effective control or authority over an area, a place, an individual, or a transaction, they are bound by their fundamental obligation not to engage in or contribute to such acts. In fact, an obligation to prevent those acts from happening. States, moreover, have an obligation to protect persons from torture and other ill treatment and to ensure a broad range of obligations whenever they are in a position to do so by virtue of their control or influence extraterritorially over an area, place, transaction, or persons. States have no discretion and are obliged diligently to and effectively to investigate all allegations in which there are reasonable grounds to believe that torture may have occurred. The core purpose of the Convention was the universalization of a regime of criminal punishment for perpetrators of torture, building upon the regime already in existence under international human rights, customary international law, and international humanitarian law. Article 5, Paragraph 1 of the Convention Against Torture obliges states to establish jurisdiction over all acts of torture on the territoriality, flag, active nationality, or passive nationality principles. I know I'm short of time, but I want to insist that under the Convention, states are required to cooperate with criminal and civil legal proceedings involving claims of torture rather than seek to block, otherwise hinder, or ignore those proceedings. For instance, in terms of providing evidence and other forms of mutual legal assistance. Competent courts in states parties to the Convention are obligated to exercise jurisdiction over acts of torture and ill treatment, irrespective of the locus where wrongfulness took place. In this context, states may not employ restrictive doctrines such as the state secrets doctrine or political questions in an effort to obstruct investigations or prosecutions and evade responsibility for these grave breaches of international law. In addition to investigating and prosecuting, the states obviously have an important obligation to provide the right to redress for victims of torture and other ill treatment. In this regard, I have consistently called for Article 14 of the Convention to be interpreted in light of the document that's called the Basic Principles and Guidelines on the Right to a Remedy and Reparation for Victims of Gross Violations of International Human Rights Law and serious violations of international humanitarian law. Just let's call them the basic principles. The principles make clear that the obligation to respect, ensure respect for, and implement international human rights law and international humanitarian law as provided for under the respective bodies of law includes, inter alia, the duty to, one, let me just cite some of them. Investigate violations effectively, promptly, thoroughly, and impartially, and where appropriate, take action against those allegedly responsible. Second, provide those who claim to be victims of a human rights or humanitarian law violation with equal and effective access to justice, as described below, irrespective of who may ultimately be the bearer of responsibility for the violation. And finally, provide effective remedies to victims, including reparation. I want to stress that the right to a remedy is a fundamental right under international law and must be accessible to victims irrespective of where the violation occurred. Under Article 14, a state party must ensure that victims of any act of torture or ill treatment under its jurisdiction have access to a remedy and obtain redress, the right to which underpins the entire convention. I find that a state's failure to investigate, criminally prosecute, or allow civil proceedings or efforts to block or hinder such proceedings, as we have seen in the United States, that are related to allegations of torture or other forms of ill treatment, constitutes de facto denial of an effective remedy. An essential component of the obligation to provide redress under international law is the obligation not to obstruct redress or obstruct access of an individual to an effective remedy by invoking state secrets to dismiss lawsuits in limine litis. This has regrettably been the case regarding victims of rendition and other extraterritorial acts of torture and ill treatment that have sought redress from the United States government. Thank you.
Thank you, Juan. Our next speaker is Claudia Paz. Claudia is the former Attorney General of Guatemala. She is the person who is largely responsible for the 2013 prosecution of former dictator Rios Montt. She's going to speak in Spanish, and I'm going to switch from moderator to translator. Adelante.
Muchas gracias, Jean-Marie. Muchas gracias a las organizaciones que organizaron este evento por invitarme. Se me solicitó compartir con ustedes la experiencia de Guatemala en los últimos años para la investigación y juzgamiento de graves violaciones a derechos humanos.
So thanks to the organizations that invited me to participate today, I was asked to share the experience of Guatemala over the last several years in investigating and prosecuting grave violations of human rights.
Y quizás me voy a concentrar en una primera parte en compartir con ustedes los 3 elementos que considero fueron fundamentales para permitir que 30 años después de que estas violaciones a derechos humanos ocurrieran, algunos de sus responsables fueran juzgados.
So I will first focus on the 3 elements that I think are key to have permitted us 30 years after these grave violations of human rights occurred for some of those responsible for these crimes to be prosecuted.
Y luego voy a compartir con ustedes algunos de los efectos que considero ocurrieron luego de que obtuvimos la primera sentencia condenatoria por genocidio en contra de un ex jefe de Estado en un tribunal nacional el 10 de mayo del año 2013.
And then I will explain some of the effects that occurred after the first sentence for genocide against a former head of state in a domestic tribunal, which occurred on 10 May 2013.
Quizás empezar brevemente explicando que Guatemala tuvo una guerra interna que duró más de 30 años. Hubo la Comisión de la Verdad de Guatemala, documentó más de 200,000 víctimas mortales entre personas desaparecidas y ejecuciones extrajudiciales. Y mencionó la Comisión de la Verdad que entre los años 1980 y 1983 en el país ocurrieron actos de genocidio.
First, I should mention that Guatemala experienced an internal armed conflict for more than 30 years. A truth commission was established and determined that there were 200,000 fatal victims, victims of forced disappearance and extrajudicial execution. And the Truth Commission also established that between 1980 and 1983, acts of genocide were committed in Guatemala.
Después de la firma de la paz, no expresamente en la Ley de Reconciliación Nacional se estableció que las graves violaciones a los derechos humanos debían ser juzgadas, es decir, no hubo una amnistía en el país como hubo en países vecinos.
After the peace accords were signed in 1996, a national reconciliation law was signed. But this law stated that grave human rights abuses should be prosecuted. In other words, unlike many other countries in the region, there was no blanket amnesty law in Guatemala.
Sin embargo, había obstáculos de facto que impedían que la larga demanda de las víctimas en busca de justicia se materializara en juicios efectivos y sanciones efectivas para los perpetradores.
However, there was several de facto obstacles that effectively prevented victims from accessing justice through criminal trials.
Y este es, creo, un primer factor que permitió el juicio en contra de los responsables de el ex jefe de Estado y su jefe de inteligencia. Y el factor es la demanda de las víctimas durante todo este tiempo, la incansable demanda de las víctimas en el reclamo legítimo de justicia.
And I think this is one of the key factors that allowed these trials against the former head of state and his former head of intelligence to finally occur. It was the persistent demand of the victims over the course of these many years for truth and justice.
Estas víctimas tuvieron el acompañamiento de organizaciones nacionales e internacionales de derechos humanos.
National as well as international organizations supported these demands of the victims.
Que durante estos años construyeron casos muy sólidos que documentaban no solo el genocidio, sino casos sobre desaparición forzada, casos también sobre ejecuciones extrajudiciales.
And over these years, they were able to develop very solid cases, not only cases of genocide, but also of forced disappearance and extrajudicial execution.
Las pruebas fundamentales en estos casos fueron, por una parte, las exhumaciones que se realizaron en el país. En Guatemala se han exhumado más de 8,000 cuerpos y que fue evidencia también que se presentó en el caso por genocidio.
So some of the evidence in these cases were related to the exhumations that have been occurring in Guatemala. More than 8,000 bodies have been exhumed, and this evidence was fundamental in the genocide and in other cases.
Por supuesto, la protección, recopilación y sistematización de los testimonios de los sobrevivientes.
Also of fundamental importance was the collection and systematization of the victim testimonies.
Y un factor muy importante es que, aunque por muchos años se decía que los documentos militares y documentos de las fuerzas de seguridad que registraban por parte de los perpetradores las graves violaciones a los derechos humanos, las víctimas y las organizaciones que les acompañaban tuvieron acceso a estos documentos.
So the military documents that were registered by the very perpetrators of human rights violations in the security forces were ultimately able to be accessed by, at least some of them, by the victims and those working with them.
Este es el segundo factor. El primer factor es el reclamo de las víctimas por justicia. El segundo factor es la posibilidad de construir casos muy sólidos para ser presentados ante la justicia. Y un tercer factor es que contar con jueces y fiscales independientes.
So the first point was the constant demand of the victims. The second point was the possibility of constructing very solid legal cases. And the third factor was the fact that we were able to have judges and state prosecutors who were independent.
Guatemala, por la grave crisis de impunidad y seguridad que hubo en el país, el Estado le solicitó a Naciones Unidas el establecimiento de una Comisión Internacional contra la Impunidad y su presencia permitió la elección de nuevas autoridades tanto en la Corte Suprema de Justicia como en el Ministerio Público que fueran independientes y con un mayor compromiso hacia el juzgamiento de estos casos.
So because of the grave crisis of impunity that existed in Guatemala, the Guatemalan state requested the international community their assistance, and that led to the creation of the CICIG, the International Commission Against Impunity in Guatemala. And the presence of the CICIG permitted the election of new authorities, both in the Supreme Court of Justice and in the public ministry. And those people were both independent and committed to prosecuting these and moving forward these cases.
De esta manera, a pesar de que las primeras denuncias por genocidio se habían presentado en el año 2000 y 2001, fue hasta el año 2012 cuando se abrió a proceso el caso contra Efraín Ríos Montt y en marzo del año 2013 cuando dio inicio el debate.
So despite the fact that the initial complaints were made by victims in 2000 and 2001 in the genocide case, it wasn't until 2012 that the formal charges were brought against Ríos Montt, and then in March of 2013, the oral trial against him was initiated.
Muy brevemente, tuvimos la sentencia condenatoria, como les decía, el 10 de mayo, y esta sentencia fue posteriormente anulada por la Corte de Constitucionalidad.
There was a conviction in this case in May 2013. However, it was nullified 10 days later by the Constitutional Court.
Sin embargo, y a eso me voy a referir, a pesar de que esta sentencia fue anulada, yo tengo la convicción de que tuvo un profundo efecto en las víctimas y en la sociedad guatemalteca.
Despite the nullification of the conviction, I'm convinced that the process and the sentence had a profound effect both on the victims of the genocide and on Guatemalan society, more broadly speaking.
Creo que la posibilidad de que en una audiencia pública en la Corte Suprema de Justicia, la posibilidad de que las víctimas en este espacio pudieran declarar frente al perpetrador los horrores que habían vivido y que él era responsable, que ellos eran personas que no eran, como señaló uno de los testigos en la audiencia, que ellos eran personas y no eran animales y que lo que les había hecho era algo que estaba mal, fue un momento muy importante para las víctimas.
The possibility that the victims were able to participate in public audiences in the Supreme Court of Justice, where they could tell what happened to them, with the perpetrator of those acts present, was that they were able to express the fact that they were people and not animals, as they had been referred to by members of the military and in some of the documents was of extreme importance to the victims?
Yo considero que mientras ellos entraron en el juicio como sobrevivientes de estos graves actos de violencia y al salir luego de la sentencia fueron percibidos por la sociedad guatemalteca como, y así lo digo, como héroes de la justicia.
¿Cómo?
Héroes de la justicia.
So the victims entered the trial as survivors of the genocide, but when they emerged, they were perceived by Guatemalan society as heroes of justice.
Un segundo efecto muy importante es que en Guatemala ha habido diversos esfuerzos por fortalecer el sistema de justicia, por fortalecer la independencia judicial y la independencia de los fiscales, y el hecho de que se realizara este juicio por fiscales y jueces nacionales significó para ellos el ejercicio del poder que la ley les había dado para que ellos se sintieran empoderados para llevar adelante estos casos y para que fueran percibidos por la sociedad también como personas que ejercían este poder.
The second important effect the genocide trial has had was there were important efforts to strengthen the justice system and the prosecutor's office in Guatemala. And this trial contributed to those efforts. The fact that the trial took place in a domestic tribunal and that national judges and national prosecutors were able to exercise the power that the law gives them was empowering for them and perceived as such by society as well.
Es el mismo juez que ordenó, Miguel Ángel Gálvez, que ordenó que Ríos Montt fuera a juicio, el mismo juez que 2 años después dictó una orden de captura y de procesamiento en contra de la ahora ex vicepresidenta y ahora ex presidente de Guatemala, que estaba en funciones por casos de corrupción.
The same judge, Miguel Ángel Gálvez, who decided that or determined that Ríos Montt could be brought to trial, also dictated the order of arrest, the arrest warrant, against the current ex-vice president of Guatemala and the current ex-president of Guatemala for acts of corruption, who are now both in prison awaiting trial.
Y con esto termino. El tercer efecto fue en la ciudadanía. Quienes conocen la situación en el país seguramente han escuchado que todo este año hubo manifestaciones en las calles demandando el cese de la corrupción y demandando también juicio para los responsables de actos de corrupción en el país.
And I think the third effect of these processes has to do with citizenship. You've probably heard that in Guatemala in recent months there have been massive citizen protests in the street demanding an end to corruption and the prosecution of those responsible.
Y estoy segura que fue frente a estos casos de juzgamiento y sanción de responsables de graves violaciones a los derechos humanos, frente a la actuación independiente de fiscales y jueces, que ante la posibilidad de que hubieran retrocesos si la misma se perdiera, que los ciudadanos salieron a las calles a reclamar justicia.
I'm certain that there is a connection between the trials that were carried out in the genocide and other cases against those responsible for grave violations of human rights and the establishment of the independence of the judicial actors in Guatemala that contributed to these citizen uprisings demanding an end to corruption and prosecution of those responsible.
Así es que con eso termino. Considero que la posibilidad de juzgar las graves violaciones a los derechos humanos en mi país tuvo estos efectos, el efecto de que la verdad saliera a luz, el efecto de que un tribunal dijera estos hechos son graves, son delitos, no pueden volver a ocurrir, el efecto en los jueces y fiscales de fortalecer su labor y sobre todo el efecto en la ciudadanía de demandar justicia.
So to conclude, I believe that the ability to prosecute these grave violations of human rights in Guatemala had these effects. First, it helped bring the truth to light. The fact that a tribunal stated very clearly that these were grave crimes and that they cannot be repeated was of great significance. It helped strengthen the independence of the judicial system in Guatemala, and it helped create a greater sense of citizenship among the Guatemalan people. Thank you. Very good. Thank you, Claudia. So our final speaker for the day is Chris Anders. Chris is Senior Legislative Counsel at the ACLU, and he's been working with the D.C. Policy Office on torture issues since 2004. Chris.
Thank you. And I want to start out by thanking the other panelists on this panel for sharing your stories and also for the courageous work you all have engaged in at personal risk to yourselves. I think for all of us here, for those of us at the ACLU working on these issues, it's a lot of work that we do at NYU as well, but it's not at the same kind of personal risk that you guys have put yourselves at. And I think there's a lot. I think the great part about this panel is that I think the complicated relationship between the United States and Latin America, there's a lot that we can learn from each other, and learn from each other's wrongs and learn from what each other have done right. And I think one of the lessons I think we can all draw from this in terms of the American experience is just the tenacity and the patience that's needed to eventually bring about accountability. I told Professor Mendez before this panel began that I met him in 2005 at a meeting, and I was about, I think, maybe 6 months into my work on the torture issue, and he came into the meeting to talk about the experiences of other countries that have had similar kinds of experiences, either through torture or disappearances or other things, about how they eventually came about to a reconciliation and bringing justice within their own country. And every one of his stories ended up with, 10 years later, 20 years later, 30 years later, right? And I remember sitting there thinking in my own kind of naive trust of the own checks and balances of the United States, thinking no, we're going to wrap this up in a year. Yes, all these other countries, yes, I understand, but not here. And I think that's kind of what I wanted to spring from is really, what is it that took place here with this issue of torture and renditions and the detention program, where those systems of checks and balances didn't work. And it was really a completely broken system, and actually it still remains a broken system. Why is it that in this area, the ship really hasn't been righted? And so if you look at, kind of these, kind of Madisonian institutions, right, that you go back to your junior high civics class of, checks and balances, why aren't they working? So you look at, the three branches of government. You start out with the Justice Department, law enforcement. Why is it that, although there were reports at the time, even though the rest of the world didn't know about the torture program and renditions and everything else that was going on, why was it that there was no one at the Justice Department who was out there bringing cases, bringing serious investigations of this? Why wasn't, there's all these acts that are in the Senate torture report, the 550-page summary of over 6,000-page report. Those are all crimes. There's no. I mean, you could maybe argue here and there about what to charge somebody with, but those are all crimes, and they've long been crimes. But the Justice Department itself was co-opted into the program almost the very start. So the President Bush made a decision very early on that the United States was not going to apply the Geneva Conventions to the detainees picked up who were alleged to be Al-Qaeda or Taliban fighters. And the reason for that was primarily to get out of the War Crimes Act, to try to find a way to circumvent criminal liability for violating the War Crimes Act, which at that time had criminal penalties for grave breaches of the Geneva Conventions. Then there was a whole series of memos that were produced by the Office of Legal Counsel at the Justice Department under close supervision by the White House that tried to basically write away the prohibitions, the criminal prohibitions against the use of torture and abuse, with really horrendous legal reasoning. That, of course, would be the kind of thing that you would get a failing grade from your professor for all of the law students in the audience. Nonsensical interpretations of law. And the Office of Legal Counsel actually has a special role within the government, which is why it was selected by the White House to do these memos, because the tradition and basically the practice within the federal government is that the Office of Legal Counsel opinions basically bind the rest of the executive branch, and so it was a way to try to find a way to circumvent the criminal law, and that this was being carried out as well by the Office of Legal Counsel at the Justice Department in consultation with the criminal division that actually enforces the law. They're the ones that are going into court every day, charging people and prosecuting them for all kinds of crimes. So they were brought into the loop too. So that particular institution was broken, and it actually kind of remains broken in that to date there have been no criminal indictments or prosecutions of anybody involved in the planning or approval of any of the acts of torture and abuse. To date, there's only been, in the civilian system, there's only been one person who's ever been charged or convicted for a crime related to torture and abuse. There's one contractor very early on was charged in 2005, I believe, before the Justice Department then kind of consolidated all the cases and sent them to a much more reliable prosecutor who then never brought another case. And then even under President Obama, Eric Holder expanded the jurisdiction of a special prosecutor who had been appointed for kind of a related matter, destruction of videotapes. And that special prosecutor, after several years of investigation, closed out his investigation without any indictments of anybody. And actually without even interviewing anybody, which is still, I think, hard for all of us to figure out how you can conduct a criminal investigation and never talk to a single victim of the crime. And I think it's particularly troubling and ironic, given that a lot of the victims of the torture program we don't have to go far to find them. They're still in U.S. custody, being detained, most of them without charge or trial, like Guantanamo. So it would have been certainly very easy for the prosecutors in that case to have found and interviewed the victims of that crime. Congress is another institution that ought to have been providing an important check on the executive branch's claim of authority to torture and abuse and kidnap people in this period. But the way that the oversight is done over the CIA in particular and over the intelligence community is through the two intelligence committees. And by statute, it's very, very few members even of that committee have to be informed by the intelligence community of what the intelligence community is doing. So when you add when you add that up, there weren't even very many people who were told about the program. There's certainly questions about what it was that they were actually told, and then they were constrained from even if they wanted to, they were constrained from actions that they could take. So there was kind of a checking of the box that Congress had been informed, but in terms of action back from Congress and actually pushback from Congress, it didn't come at that time. Now later on, after the story broke at Abu Ghraib and the country saw the photos of the use of torture in April 2004, there were more serious congressional investigations. Most of these are kind of like looking back investigations, because even at that time, a lot of these practices had either stopped or were being reduced in ways and places where they were being used. And some of those were serious investigations, and in particular there were two committees that did very thorough investigations, after the fact investigations, but important ones. The Senate Armed Services Committee looked at in 2007, 2008, wrote a report and did a very complete investigation of the role of the Defense Department in the use of torture and abuse, and then more recently, although it was a more than 4-year investigation, the Senate Intelligence Committee under Dianne Feinstein did an exhaustive investigation involving 11 million pages of CIA documents, and wrote a 6,700-page report with, I can't remember the numbers, 36,000 footnotes, I believe. And we now have a redacted version of the executive summary, which is itself 550 pages, and we know a lot more. Although even in that report, one of the things I guess I was struck by with some of the conversation from the panelists earlier is it is a very good, disturbing, upsetting description of what took place by the CIA. But what's missing from it is there is no apology. If you listen to here, there's a description of what took place, but there's nowhere in there, and there's nowhere coming out of that report an actual apology. Maybe the closest we got from the president is his statement at the time this report came out of, well, we tortured some folks. But that was not followed by, and we apologize for that. And I think that's certainly part of the healing process. So at this point, we basically have no apology. We have no criminal indictments. And then I think the last piece is the other branch of the government that could have oversight over it is the courts. And here again, we've had a failure by the courts to exercise oversight, where a number of different lawsuits have been brought on behalf of the victims of these crimes, torture victims, and the courts repeatedly, at the urging of the Justice Department, have found ways to get these cases dismissed without the cases ever going to discovery, and certainly without going to verdict. And just one last piece, since it's a case that was just filed last week, and it's one I think for all of us to watch. It's the ACLU filed the case on behalf of 3 victims of the CIA torture program against 2 of the psychologists identified in the Senate Intelligence Committee report, who were the ones who helped put together the whole program for the CIA, and so we're trying to find another way, using the new information that is now public through the Senate Intelligence Committee report, as well as the accounts from these former detainees and their families themselves, to get accountability through the courts. And it's going to be a long road, but I think that's one more way where we're going to see if one of the institutions of government that really should be serving as a check on the executive branch will actually step up and actually allow these detainees to have their day in court and to hold the government accountable. But it's, I think as as the experience of all three of the other panelists show, it's, it is a long road. We're more than, we're now 11 years out from, I think, when the country first heard about Abu Ghraib. We're hoping it's not going to be a 30-year experience, but I think that there is good reason to keep working on these matters and keep pushing to bring that to resolution.
Thank you, Chris.
Thanks.
So before I open it up for Q&A, I would just like to say one very brief thing, and that is that in addition to what we've heard from our speakers today, I think the Latin America experience in seeking justice and accountability as well as reparations for victims is extraordinarily rich and deserves further study and further attention on our part. One of our co-sponsoring organizations is CELS, and CELS has really been a leader in Latin America litigating these human rights cases after years of impunity. But they managed to have the amnesty laws that prevented prosecutions overturned, and once that happened, prosecutions started off kind of on in a trickle, but eventually we're now at a point where there are dozens of trials going on in Argentina throughout the country, and several hundred former members of security forces, as well as civilians, as well as corporate executives are being held to account for the atrocities that occurred during Argentina's last military dictatorship. And we see this experience repeated in places like Chile, Peru, and we've heard about the Guatemala experience, Uruguay as well. So I think that Latin America actually has a lot to teach us about how accountability can actually be constructed. And it's about the perseverance of the victims, as Claudia spoke to us. It's about the independence of the judiciary, which we have an independent judiciary here, but for some reason it doesn't quite seem to be working, as Chris was mentioning. So I think it's worth us thinking a little bit more about the Latin America experience. So thank you all again for coming, and we have about 15 minutes of Q&A, so please, Joy.
Hi.
Well, we have a microphone, and maybe if you would mind identifying yourself.
Hi, I'm Joy Olson from WOLA. So since I'm I suppose I shouldn't ask a question since I'm one of the organizers of the event, but I'm sitting here listening, and the question that weighs on my mind is, what are we missing? From the examples that you gave on Guatemala and thinking about Argentina and Peru and so many other places, what is missing in the United States right now that we can't seem to get over the hurdles of accountability that we find important? Do we have any reflections, Juan? You've been looking at this a lot in different parts of the world. What are we missing?
Thank you, Joy. Let's take a couple more questions, and I'll turn it back to the panelists for a quick series of responses. So way to the back.
I'm Stephen Mullen from the ACLU. I just have a question, and I think it adds on to the last speaker's question, is how we translate the accountability success in Latin America, or replicate it, rather, here in the United States when and I think this goes to your question too, when the victims and survivors of torture and disappearances are over there, they're not here. And in Latin America, they were there, the families that Mother to Plaza de Mayo were marching until they got accountability. And all we have here in the United States just now is some transparency on the issue. How do we move from transparency to accountability?
Yes, there's one more question over here.
Hi, I'm Teresa Harris with the American Association for the Advancement of Science. I'm curious about the role of truth commissions in the path to justice. That was a piece, I think, that hasn't maybe been touched on in getting from the beginning of the of the transitional justice path to the kind of accountability that you're talking about.
And maybe one more last question for our panelists? If not, then I'm going to turn the floor back over to you, and if we would maybe go in the same order that we
Okay.
presented. Reverend Morris, do you have any comment?
I didn't hear any of the questions.
Oh. The first question from Joy was, what's missing? Why are there no prosecutions here in the United States? The next question from the back, from our colleague from the ACLU was, in thinking about Joy's question, does it have something to do with the nature of who the victims are, right? In the United States, the victims are over there. They're foreign. They're the terrorist other, right? Whereas in Argentina, they were the mothers of the Plaza de Mayo. They were from Argentina. Does it have something to do with that? And the final question asked, what was the role of truth commissions in the path from impunity to accountability?
Well, I would say I think what's missing here is related to the other question. My case had a powerful result because I'm an American citizen. People really got pissed to hear that an American missionary was being tortured in Brazil. They didn't care about Brazilians being tortured in Brazil or Argentinians being tortured in Argentina. That's a human thing. It's not just American failure, but we're all very parochial. So we're concerned about our group and so on. So if it's not our group that's being tortured, we're not as much mobilized. Add to that the general alienation of our population caused by the kind of mass media we have and the massification of people's concern. We've been seeing since at least the Nixon administration, the American people voting against their own interests time after time to put in power a government that goes against their interests and doing it again and again because they really don't understand the issues. So I think there's a lot of that is involved.
Thank you so much. Juan.
Well, I think Steve has put his finger on what's missing, as Joey asked. I think what has happened in the United States is that the torture victims are foreigners, they are aliens, they are people whose names we can't pronounce and whose photographs all look the same to us. And of course, that means that there's very little solidarity with them. Solidarity is what in Latin America brought increasing circles of society to realize that this cannot be tolerated and that impunity for these things could not be tolerated. And solidarity is very difficult to exercise in a situation in which not only in the United States, but in the whole world, the culture acts against us because it pushes us to believe that torture may be ugly but necessary and somebody has to do it and it does keep us safe and all that. So one fault that I had with the discussion about the Senate Select Committee report was that it focused all too much on whether torture works or not, whether it's effective. And that basically persuades a lot of people in the United States and elsewhere, as I said, that if it is effective, then we have to live with its ugliness. And first of all, it's not effective. It just dilapidates efforts. It sends law enforcement agents into all kinds of wild goose chases. It gives bad information. But worst of all, it's ineffective because in the end, the price that law enforcement bodies and intelligence bodies pay for engaging in torture is very high. And that's what we learned in Latin America, that now when we have serious problems with drug and crime, we don't have a law enforcement body that we can trust. Because in the past, our military governments, our unelected governments, let them run roughshod, and they're used to impunity. They continue to act without engaging the community, without asking for support and cooperation. So we do pay a very large price, to say nothing of the emotional price that we all pay as a society and as individuals. I think, but saying what's missing, should also be tempered by the fact that what the United States does have is a very vibrant civil society, organizations like the ones you work with, that from the very first moment resisted torture and and insisted on accountability. And that they have created a groundswell of support that at least has resulted in transparency, as Steve put it. The next step is accountability, and I don't doubt that we'll get there. We'll find the ways. It's going to be a very distinct American way of a struggle against impunity, but there will be some. Of course, it won't be automatic by any means. It will depend on the efforts of men and women and of all of us. It will demand sustained effort. It will demand requiring that institutions of the state that are there to protect the citizen live up to their obligations and do their work.
Thank you. Claudia, ¿tú quieres comentar?
Quizás sobre la pregunta sobre comisiones de la verdad. En Guatemala tuvimos una comisión de la verdad, estaba establecida en los acuerdos de paz y tuvo un rol crucial. La posibilidad de que las víctimas presentaran sus testimonios, que sus testimonios fueran recogidos en un informe, creo que tuvo un efecto muy importante en tres aspectos.
In Guatemala, we did have a Truth Commission. It was the result of the peace accords, and it played a crucial role. The fact that victims were able to testify before the Truth Commission and that their testimonies were then collected in a final report had three important effects.
Uno sobre los hechos, porque habían, sobre todo los perpetradores mismos y los otros grupos sociales que simpatizaban con los perpetradores, había un esfuerzo muy grande por negar que todo esto había ocurrido y el informe de la verdad pues sacó a luz las graves violaciones a derechos humanos que habían pasado en el país.
So the first of these is the fact that the perpetrators and those who sympathized with them went to great efforts to deny the existence of human rights violations in Guatemala. The Truth Commission brought those violations to light, made them transparent.
Y al visibilizar los hechos, al visibilizar a las víctimas y al menos en el caso de Guatemala, nombrar a los perpetradores, que más del 90% de las violaciones de derechos humanos fueron cometidas por el ejército, el efecto simbólico que esto trae es que esto ocurrió y que son hechos que no deben ocurrir de nuevo.
The second effect was that by making visible the fact of human rights abuses and allowing the victims to speak publicly, also naming the perpetrators, the fact that 90% of the violations in Guatemala were committed by the Army, had a very important symbolic effect, both to determine that this did occur and that it should not be allowed to occur again.
Y tuvo también un efecto como de abrir camino hacia los juicios. El mismo informe de la verdad ha sido utilizado como evidencia en los procesos posteriores.
And it absolutely played a role in opening the pathway to justice. For example, the Truth Commission report was used as evidence in the genocide and other criminal trials in Guatemala.
I'd like to add another thing. I blame John Wayne for a lot of the missing part here, because since his first movies back in the late 40s, he always saved the girl by beating up on the villain to find out where she was. And the American people have been conditioned by this kind of entertainment that violence, which is torture, is justified for a good cause. And that's been going on in our population. This horrible TV program, 24, justifies every week that to save New York City from a nuclear bomb, it's all right to torture people. And people are conditioned and reconditioned and conditioned. It goes on all the time. And I think the average American citizen, as Juan said, when you're talking particularly about somebody whose name you can't pronounce, well, of course you beat the crap out of him to get the truth, because we need that, and it's justified. And I think we've been conditioned, really, for 60 years to accept this kind of violence for a good cause.
Thank you. Yes, thank you. Chris, I'll give you the final word we have.
Yeah. So I mean, I think this is these are this is the heart of the problem of how you motivate people on this issue, because we don't have, unlike Latin American countries, the victims of torture living here among us. I think too, if you look at people that have taken action, particularly people in Congress who have been on the right side of this issue, I think two things seem to motivate people. One is, but they're both a little more intellectual. I think one is that I think it reflects the use of torture and abuse. I think reflects badly on our own self-image of who we are as a country and who we are as a people. And I think these are disgusting acts, horrific acts, and I think for many Americans, I think knowing that our government engaged in them and that there hasn't been accountability, who we are as a people and our own self-image. I think the other one is I think it maybe has a little more limited utility, but I think also has been important, which is that is a lot of foreign relations, a lot of international relations is still kind of a tit for tat world, and how we behave towards others is how we get treated by others, and I think there's a realization by many people, certainly in the military, that if you don't comply with the Geneva Conventions and you torture people and you kidnap people, that's how American soldiers are going to be treated in future conflicts, and that this prohibition against torture and abuse is maybe more fragile than some of our laws make it seem, and that it really is. There's a lot of reliance on self-policing by individual countries, particularly by the United States. So I think it's more. I think it does require more thoughtfulness and more intellectual engagement than actually having a community of people who are actually tortured living among you. But I think that our hope is that those kinds of ideas carry us through to true accountability.
Thank you. I would just like to close by thanking the NYU campus here in DC for hosting today's event and helping us organize it, and to CELS, Conectas, WOLA, and Sahil, and the ACLU for putting this wonderful event together, and to all of you for joining us.